Jeremy, you are the founding partner of Welbeck Solicitors, known for its specialism in debt collection. What is meant by the term zombie judgment that one often hears about in the legal press?
Yes, it's not a legal term as such, but as you rightly say, in the press, a zombie judgment refers to the situation where a creditor has gone to the trouble of taking a debtor to court, securing a judgment, but not enforcing it. So they've done all the hard work, but of course, that doesn't necessarily mean that they've got their money. They have to enforce it. So enforcement proceedings often have to be taken.
What can be done?
There are several ways or methods of enforcement, and it really depends on the facts of the case. Firstly, you could obtain a warrant of execution, which means that the sheriff or the High Court enforcement, as they're now known, actually levies execution on the assets belonging to the judgment debtor. Secondly, a creditor could apply to the court for what's known as a third-party debt order. That effectively is an order from the court which intercepts an existing debt owed by a judgment creditor to a third party. So a typical scenario would be a bank that's in credit. So your judgment debtor has a credit balance in his bank account, and you as a judgment creditor can apply to the court to effectively freeze the bank account and have the balance of the account paid to you, the judgment creditor. Thirdly, if the debtor is in employment, you can apply for what's known as an attachment of earnings order. That means that the court orders the employer to pay instalments on a monthly basis to the judgment creditor out of the judgment debtor's wage or salary. Fourthly, you can also apply for a charging order if the judgment debtor owns his own property. Firstly, you would apply for the charging order, and if that's secured, you could then follow with a second application for an order for sale. So effectively, the property would get sold, and as long as there is equity, then after the mortgage and any other mortgages secured against the property, the judgment debt would be paid. Lastly, there is also another means of getting paid, and that's through the use of bankruptcy proceedings if your judgment debtor is an individual, or winding up proceedings in the event that your judgment debtor is a company.
What type of enforcement action would you recommend?
Well, as I say, it really depends on the facts of the case, and we would look at the situation very carefully before we gave that advice. Bankruptcy and winding up proceedings can work if you have a judgment and it's not disputed, but equally a charging order might be the best way forward in the event that the debtor has a property. What
about statutory interest?
Statutory interest, yes. Until April 1993, it used to be 15%. And although it's discretionary, the new statutory limit is 8%. So courts will usually award interest, but as I say, it is discretionary.
Finally, can the judgment creditor enforce a money judgment beyond 6 years?
It's difficult to do so. You would have to look at the facts of the case carefully again, but under Section 24 of the Limitation Act 1980, the usual cut-off point is 6 years from the actual judgment or from the date when the debt accrued. So normally, make sure that you do take action before 6 years has expired. The other point, of course, is that you don't want to just wait around, because the debtor's circumstances might change. And when I say change, I mean for the worse. So our advice is, as soon as you've got the judgment, then talk to your solicitor about taking enforcement action.
Thank you, Jeremy, for your time.
You're welcome.